Hi, my name is Wouter Meester from the OECD Competition Division, and I'm joined today with Deniz Both, who is lawyer and expert on international competition law and trade. And yesterday we had a session during the Global Forum on Competition where we spoke about regional competition agreements. So yesterday, Deniz, you spoke about the relationship between international competition law regimes and international integration agreements.
Yes.
Can you maybe elaborate a little bit on this relationship?
Okay, so first of all, I'll start with defining what I mean by regional competition law regimes. So I define this term as a model of regional enforcement of competition law, where in connection with a deep economic integration agreement. So member states to a deep economic integration agreement enter into adopt a binding regional competition law and establish a competition agency, a regional competition agency with law enforcement powers. So that is what I define as a regional competition law regime.
Right.
So why the link between regional competition law regime and regional economic integration matters? Well, for several reasons. First of all, when we look at all existing regional competition law regimes, we see that they are formed in connection with a deep economic integration agreement. And when we look at the provisions of these deep economic integration agreements, we see that competition policy is often not among the primary purposes of the integration agreement. So, which means that competition policy is often seen as a supplementary policy or a tool for the pursuit of core objectives of the integration agreement. That is important because there seems to be no political will to adopt a regional competition law regime on the basis of a standalone agreement. And therefore, we do need a regional integration agreement to give legal effect to the regional competition law regime. And we all know, secondly, that establishment of a regional competition law regime is a long and complex process.
Right.
So it requires harmonization of laws across the member states. It requires significant investment, funding, and institutional reforms, and also training and constant cooperation between the member states. So investments into a regional competition law regime, especially in the founding stage, involves high risks, in particular when member states have concerns about one another's enforcement capabilities and also political and economic backing of the process. And political and economic backing of the member states is crucial for the establishment of a regional competition law regime. And it appears to me that such political backing is only available when the member states are fully committed to the relevant regional integration agreement. Right. In other words, when the member states are receiving or are in the belief that they will receive in a foreseeable future economic or non-economic benefits from the integration agreement, the broader integration agreement, then they are more likely to be supportive of supplementary policies like competition policy. And lastly, why the link between regional integration agreement and regional competition law regime is important, because the regional integration agreement itself may alter the goals of regional competition law. So regional competition agencies might need to pursue the additional goal of strengthening economic integration in the enforcement of competition law. So for all these reasons, regional competition law regimes and regional integration agreements are linked together and they need to be considered together.
Right. And what does it mean in practice?
Well, yeah, it means, several things can be said, but first of all, I think one can argue that the more the regional competition law regime supports the primary goals of the regional integration agreement, the more support it will receive from the member states.
Right.
Therefore, regional competition agencies might be considering the ways to make regional competition law and policy more supportive of the broader goals of regional competition, regional integration agreement. And this might happen in several ways. For instance, it might happen by prioritizing industries that have greater potential for intra-regional trade, or it might be through research and advocacy activities, highlighting state-imposed barriers to intra-regional trade, or it might as well be done by pursuits of a common market objective in the enforcement of competition law. So, but all in all, it appears clear to me that a regional competition agency has to be conscious of the link between a regional competition law regime and regional economic integration agreement.
Absolutely. Thank you so much for this clarification.
Yeah,
thank you for being with us today and yesterday as well.
Thank you for inviting me.